Hello, I'm Dr. Sam Godfrey from Cancer Research UK, and my superb colleagues in the Legacy team have asked me to introduce this Charities as Beneficiaries session to give you some detail on the ways in which Cancer Research UK is supporting people with cancer and their families at this difficult time. And because I'm a massive science nerd, I also wanted to tell you how we've been able to use some of our considerable research expertise to help track, understand, and defeat COVID-19. Many of the scientific techniques and approaches that our researchers use, like understanding how a disease spreads, the basic mechanics of it, engineering therapeutic viruses, working with the immune system, they are all disciplines needed to tackle the COVID-19 virus. And so our scientific family has stepped up to the challenge, actually quite heroically. They have been providing essential kit, machinery, scientific skills to the national effort to beat this disease. Our scientists from all levels, from our chief clinician down to PhD students from all across the UK, they've been instrumental in setting up and running testing hubs for NHS frontline workers and patients. We have scientists helping test experimental vaccines, scientists working in new and repurposed drugs, all aimed at tackling COVID-19. Our research nurses and clinicians, they've joined the mega NHS life-saving effort whilst still supporting cancer patients where they can. And that is just the science and the medical side of our work. People with cancer are having to deal with the risk of the virus, the changes to their treatment plans, isolation from their support networks. And so that's why we're also working hard to give them the latest information and advice, whether that's on our website or whether it's through our experienced cancer nurses on their helpline to advise anyone who needs it. And at the same time as all of that, we're monitoring the impact of COVID-19 on cancer patients right now so that we can help the NHS recover quickly and pick up cancer services as rapidly as possible. It has been genuinely inspiring to see so many people come together from so many fields at this time, even more so when we've been forced to do this on a backdrop of difficult funding cuts to our life-saving research. Our ambition hasn't changed. We will still beat cancer, and the sooner we can beat COVID-19, the sooner we can crack on with that. With legacy income accounting for approximately a third of our research funding, we are enormously grateful to you for continuing your work, writing wills for clients in difficult circumstances, for administrating estates where Cancer Research UK is a beneficiary. And because you're key workers, we recognise the sacrifices that you are making to offer your professional legal advice, to allay fears around estate planning and to guide people through probate. So we are here to support you, and my colleague Maria, Head of Legacy Professional Partnerships, will now take over and run through some detail on how we can support you and your clients in the wish to improve cancer prevention, diagnosis and treatment in the future. Thank you.
Hi, and welcome to this CPD video on Charities as Beneficiaries. I'm Maria King, and I'm a private client solicitor of 18 years PQE. Having practiced in smaller national firms, I'm now Head of Legacy Professional Partnerships at Cancer Research UK. Cancer Research UK is the UK's largest charity, and we deal with over 6,200 legacy gifts every year. My team includes a number of case handlers, most of whom are legally qualified or have a background or experience in legacy administration work. I'm also Director and Chair of the Institute of Legacy Management, which is the umbrella and member organisation supporting charities in their legacy administration work through training, forums and acting as a voice for the sector. So there's not much that we haven't seen at Cancer Research UK in terms of charitable legacies, given the large number that we deal with year in, year out. So in the time that we have today, I will cover a few of the legal issues specific to charities under each of the following headings. So that's will drafting, probate admin and contentious matters. And I intend to do this in an interactive way by asking you some questions, getting you to think about situations and telling you about some real life case studies that we've actually seen at Cancer Research UK. There is a lot more detail in the Law Society and Institute of Legacy Management joint publication, Charities as Beneficiaries, which is available free to those who are members of the Law Society Private Clients section. You may also want to read an article I wrote for the Law Society Private Client section magazine in November 2019 on the pitfalls of charitable will drafting. So what I've chosen to speak about today as far as will drafting goes is charity identification and inheritance tax, in particular the impacts and issues surrounding charities ceasing to exist and their merger, and then the special rules that apply to the apportionment of inheritance tax when dealing with gifts of residue. To start us off, there's the obvious about making sure a charity is described correctly. Do not rely on your client. Check sources like the Charity Commission for the full title and registered address and charity number. You'd be surprised how many times this does go wrong. We'll pick up on some of the issues later on in this presentation. A lot of charities may have changed their name or structure or merged between will drafting and probate. So I'd like you to think about this question below. So Imperial Cancer Research Fund and the Cancer Research Campaign merged in 2002 and formed Cancer Research UK. What do you think happens to legacy gifts to ICRF and CRC for deaths post-merger? Is the answer the legacy automatically passes to Cancer Research UK? The legacy may pass to Cancer Research UK. The legacy will fail, or something else? So pause the video, have a think about what your answer is, and then restart again once you've picked your choice of answer. So, what is the answer to this question? Well, the answer is that the legacy may pass to Cancer Research UK. Let's look at why on the next slide. When two charities merge, a legacy gift to either of them will not always take effect as a gift for the successor charity. This is because although there are statutory provisions designed to prevent such a failure, there are shortcomings with these. The current legislation in the Charities Act 2011 does not specifically encompass legacies which have been made to charities that have ceased to exist at the date of death. The Law Commission recommends that a legacy should take effect as being for the transferee in a merger. A government response to the report in which this is contained is currently awaited. Until then, shell charities exist. So Cancer Research UK and the Imperial Cancer Research Fund are examples of shell charities. Effectively, the only purpose of these charities is to receive legacy gifts before the funds are transferred to Cancer Research UK to be used into research into cancer. A sizable amount of our legacy income still comes from these two funds. The administration work is, however, centralised, and my one team that deal with legacies from Cancer Research UK also deal with the administration side of these legacies that come into Cancer Research Campaign and the Imperial Cancer Research Fund. We also still get gifts for ICRF and CRC in wills that have been written post-merger, even though that was some 18 years ago, which was not a problem for Cancer Research UK in light of the fact that we have these shell charities. I'm sure you can see that for some charities who may not have kept a shell, this could be a problem. So please do check the right name when drafting, along with the charity number and address, anything that may help identify the charity of choice when the time comes to administer the will. The Charity Commission do keep a register of charities which have merged, which can be checked on the Government UK website. It is also good practice to include a general see pray clause in case any named charitable objective can't be carried out at the time of probate. So here's another question to get you thinking about. So here we have one of 5 residuary charities ceases to exist after death but before distribution of the legacy, and the legacy has been left on equal shares to these 5 charities with an accrual clause. There is also a see pray clause, a general see pray clause in the will. What do you think happens to the legacy? Is it that the executor can use discretion to distribute the ceased charity share to an alternate charity with a similar purpose? Or is a court direction needed? Or is it shared between the 4 remaining charities? or is it something else? So again, pause the video if you need to, and then restart when you have your answer. So the answer is, it's shared between the 4 remaining charities. Now that may have surprised a few of you, so let's look on the next slide at why that is the case. So this scenario is from a real case that we saw at Cancer Research UK. Whilst the CRUK clause does provide the executor with the discretion to benefit a replacement charity in the event that the purposes cannot be carried out, the timing of the charity ceasing to exist threw a spanner in the works here. And the critical thing from the last slide to have noted is that the charity ceased to exist after death but before the distribution of the legacy. So let's actually have a little bit more of a look at this. So take a look at the clause which you'll see on screen, which is taken from the will in question. Pause if you need to. You will see that the CRUK clause is clearly defined to only operate in respect of charities that have ceased to exist before the death of the testator. And you might remember from the last slide that the charity had ceased to exist after the testator had died but before the legacies were distributed. So in this case, counsel was instructed by the executor, and his view was that the executor was acting outside of his authority to distribute a 20% share to an alternative charity under the CRUK clause. His rationale is, as you will see on the bottom of the slide now. So to sum up his counsel's opinion, words should be given their ordinary and natural meaning. The clause was not expressed to have effect when an institution had ceased to exist after death but before distribution of the residue. So the point that I've just made. One might, however, take the view that had the testator been asked what she wanted to happen in the situation that has arisen here, it would have been her intention that the clause on the screen would apply. However, there was no evidence in the will or the will file or otherwise an indication of what the testator would have wanted here. Theobald on wills was quoted by counsel, who also clearly set out why a construction or rectification claim was unlikely on the facts. So looking on the slide, unlikely case for construction application under section 48 of the Administration of Justice Act 1985, because if the will simply does not deal with the situation, then the court cannot supply a provision. And in terms of rectification under section 20 of the Administration of Justice Act 1982, rectification is not available for a lacuna in the will because the testator never had any intention relevant to the events which actually occurred. So if we have excluded rectification and construction, what was the outcome? So counsel's advice and opinion was that the executor would be acting outside the scope of his powers by distributing the remaining 20% to the alternate charity of choice. Whilst it was arguable that the clause on this slide ought to be construed or possibly rectified to cover the situation that had arisen, it was his view that such a construction was not irresistible. Sharing the 20% between the remaining 4 charities as named in the will was in compliance with both the accrual clause and also the CRUK clause, which purely gave discretion for the executor, in the right circumstances, to favour an alternative charity. An alternative would be for the executor to apply for guidance under Part 64 of the Civil Procedure Rules on the administration of the estate. However, it is difficult to understand the benefit that the time and cost of taking this approach would give, given that even if this clause was held to apply, the executor would not be obliged to exercise his discretion under it in any case. As I'm sure you're aware, all legacies to charities usually attract the full inheritance tax exemption from the usual 40% death rate. The inclusion of charitable gifts in a will can therefore substantially reduce the inheritance tax burden on an estate, so it's always worth considering whether leaving a charitable legacy is something of interest to your client, and if it is, whether leaving 10% or more in order to attract the lower 36% rate of tax is something the client wishes his estate to benefit from. Contentious probate disputes can arise under unclear will drafting. These types of cases can be both costly and delay the administration of the estate. Section 41 of the Inheritance Tax Act 1984 must be borne in mind where the residuary estate is to be divided between charitable beneficiaries and other beneficiaries who are subject to tax, for example, family members. This provision states that the exempt gift in a will should not bear tax that arises on any other part of the residue. It is possible to work around this though, and there are two cases that are authorities on this point. You have Re Benham and Re Ratcliffe. So Re Benham provides for charities and non-charities receive equal net amounts after tax and is achieved by clear drafting to support that view. Ratcliffe is the default position. Charities benefit from gross estate before tax unless wording provides for a Benham division. And it is a common mistake to apply Benham, which infringes Section 41 Inheritance Tax Act 1984, where there isn't sufficient drafting to support an alternative division. So it's worth having a look at the clause I've just popped up on the screen and having a little think about whether you believe this is a construction under Re Benham or Re Ratcliffe, and half the estate goes to charity and half to the testator's family. So pause the video, have a quick read through and think of your answer and then come back. So what is the answer to this question? Well, this is a Ratcliffe construction, and let's just take a look on the next slide to understand the reasons for that. So just to be clear, that's where the charities will benefit from the gross estate before tax, and then the non-charitable beneficiaries will have tax deducted from their share. So in other words, the non-charitable beneficiaries will receive less than the charity beneficiaries who are not subject to any tax. So first of all, we have a Benham construction. So an example is, I declare that the shares of my estate of any beneficiaries who do not qualify for exemption from inheritance tax shall be deemed to be of amounts such that the amounts received after payment of inheritance tax due shall be the same for all the beneficiaries named in clause X. And you will appreciate that this is different from the wording in most professionally drafted wills as part of the normal testamentary provisions, which direct that estate should be divided after payment of debts and funeral and testamentary expenses, including inheritance tax, but do not, however, direct that the charities and non-charities should receive equal net amounts. And that is the key thing, I think, to take away from this. Let's have a quick look at the Ratcliffe construction. I declare that if the share in my estate of any beneficiary named in clause X does not qualify for exemption from inheritance tax, that share shall bear its own tax, so that the amount received by each beneficiary named in that clause is the same before the payment of inheritance tax. So Ratcliffe established the principle that the gross approach should always be applied in estates that are divided between exempt and non-exempt beneficiaries, unless there is specific wording in the will to provide for a Benham division. So the example clause that you've just looked at on the previous slide lacked that specific clarity for Benham to apply, and it would need to be drafted in a much more explicit way to be effective. and this was a real case at CRUK. It was clear from the estate administration that the solicitor was sharing with us that the inheritance tax burden was intended to be shared across the charities and the non-charities. So we went back to the solicitor and highlighted the issue of Benham and Ratcliffe, and the solicitor did accept that this was a Ratcliffe construction. So the full inheritance tax burden was borne by a single non-exempt, and the charity ensured it received its full income entitlement. It's this sort of thing that is looked for upon audit of charitable files, and so it's really important that we make sure that we've received what the testator did indeed intend for us to receive. So it's also worth noting that a Benham approach is not often drafted, but you should, however, be aware of it for as and when it might be relevant to your client at the drafting stage or when you are administering a will. Let's move on to think about probate administration. I'm firstly going to spend a few moments chatting through communications between solicitors and charities, and why charities might ask for the information that they do. The requests made by charities often have regulatory or governance principles behind them, and sometimes approaches will vary depending on the size and structure of a charity. Secondly, I will speak a little bit about capital gains tax and how to help maximise the use of the charitable exemption. And lastly, I will speak about the misdescription of charity names and incomplete gifts, along with some practical solutions for how to navigate these situations. So first of all, on the communication with charities, it's recommended that charity beneficiaries are notified of an interest in a will or a codicil as early as possible. This is appreciated by charities for a number of reasons, which I'll come on to in a moment. So first of all, I want to mention SME and Forward, which is a notification company that a lot of charities subscribe to, and every week they will receive copies of all the grants of probates newly issued by HMCTS in that week. SME and Forward will then read them, and for any subscribing charities, they will notify the charity of any legacies that have been left to them, and they will provide the information from the grant of probate, including a copy of a will. So why is it that charities sign up to this SME and Forward notification company? And there's some key reasons really as to why we do that. So in terms of receipts, where a charity has a number of contact points, so it could be shops, regional offices, local supporter branches, for example, early notification enables the nominated charity legacy professionals to correspond with the executor and ensure that payment is received by the correct part of the charity. Otherwise, it can cause administrative issues. For example, an individual executor could end up making a payment as a donation or an in-memory gift rather than towards the legal entitlement that is a legacy. Charity fundraising teams are typically large, and it's likely that donations are dealt with by different teams to legacies. The offshot of this is that sometimes we may end up chasing an executor who has already made the payment. It's just they've made it to the wrong part of the charity. So early notification means that we can get in there quick and let them know all the information that an executor needs to know to make the payment to the right people. Another reason is about stopping comms. So those who leave bequests to charities may also have been supporters of those charities during their lifetime. They may therefore have subscribed to charity newsletters and may receive mail-ins about fundraising appeals. When executors inform a charity of a legacy gift, the charity takes steps to ensure that no further correspondence is sent to the deceased supporter's address, for example, by suppressing any database records on that supporter. Receiving charity mail-ins once a loved one has passed away can cause distress, as I'm sure you can imagine, and so charities rely on executors to help them avoid this situation. Another reason is legacy gifts account for a substantial part of many charities' income, and early notification will help a charity to plan their charitable resources and projects. So at Cancer Research UK, about a third of our income, so around 170 to 180 million pounds each year, comes from legacy gifts, which is absolutely amazing, and thank you for your support in helping us to achieve that. For smaller charities, cash flow can be more of an issue than for bigger charities, so giving an early heads up about a legacy that's in the pipeline can be incredibly useful to them. Another reason why we like an early notification is to comply with our audit requirements. So charities will have financial audits as other companies would have, and they should therefore have regard to the Statement of Recommended Practice, or SORP, FRS 102, link on screen if you want to take a look. In terms of charitable income recognition, income needs to be recognised when the following three criteria are met, as on your screen. So entitlement, can the charity say it has rights to the benefit? Probable, is it more likely than not that the benefit will pass to the charity? And lastly, measurement, can the monetary value of the benefit be measured? Although the exact application of these criteria is a matter between individual charities and their auditor, a lot of charities will accrue for their legacy income upon notification of their legal entitlement to a legacy. So, for example, at the grant of probate stage, and some information from which to estimate their entitlement. Again, that may be the information given on a grant of probate. It's this accrual that could form the lion's share of the legacy income recorded in a charity's annual accounts, and it's therefore important that estimates of accrued legacies are kept up to date and revised often. So estimates at Cancer Research UK are first formed from the basis of the SME and Ford or the grant of probate, which will then further be refined by taking into account the information in the will, which may tell us of other legacies that aren't to do with us, so we can start to put the bits of the jigsaw puzzle together and work out our entitlement. A schedule of assets and liabilities from yourself as solicitors are further useful in refining this estimate, as are changes to valuations throughout the probate. For example, property valuations and share sale prices. The most accurate estimates comes from the final estate accounts. So as you can see, the legacy officer is in effect working to push the value of the legacy down through a funnel of increasing accuracy to meet its auditor's requirements. It's therefore extremely helpful to forward the things listed on the slide, namely wills and codicils, schedules and changes in valuations, and interim or final estate accounts once you have them to hand, so that the legacy officer can input the data into the computer systems and satisfy audit requirements. And I hope that that is helpful to understand why it is that charities will be asking for this information, or particularly keen to hear from you on these particular things. It's always a good idea to consult with charities before agreeing the sale of estate assets, and generally this is because experienced legacy officers can often add value to the charity's legacy entitlement. This could be due to tax reasons, for example having a brilliant working knowledge of how to capitalise on the charity's capital gains tax exemption. We'll come on to an example of that in just a moment. Or it could be that they're able to tap into preferential rates with particular auction houses, jewellery specialists, stockbrokers, etc., which in turn, if we're reducing costs, will maximise the legacy due to both charities and potentially individuals too. And there can also be regulatory issues. For example, the Charities Act 2011 has particular requirements around charitable property transactions, and we'll look at that in just a moment. So in terms of liaising with a number of charities, on average there are 3 to 4 charities per charity will. I think it's also worth noting that by the time we're dealing with a probated will, charities are not competing against each other to win a legacy, so to speak. It's also worth noting that in the legacy sector we work in a very, very collaborative way, and lots of legacy officers across charities do know each other on a first name basis. By and large, people are all members of the Institute of Legacy Management and will frequently network with each other. So there's a lot of sharing behind the scenes and discussing of decisions behind the scenes. So it's just worth bearing that in mind when you come to writing to charities. We probably do prefer, on the whole, our comms by email. And I guess if you are writing to one of us, there's a very, very large chance that the other charities, for the reasons that we were just discussing on the last slide, will be interested in information, the same information. So it's probably a really efficient way to write an email and just add all of the charitable co-beneficiaries to that same email comms. That's very helpful from our perspective to know that all of our co-beneficiary charities have got the same information, and we can jump on the back of that and make decisions, consider the same information at the same time. So in terms of governance and decision making, it's worth noting that each charity will have its own delegated authority down from the trustees to the legacy administration team, and what this will do is it will very clearly outline who can do what and how. And whilst there are general principles that guide delegated authority, the different sizes, structures, etc. of charities will mean that there is no universal standard. It can mean that some charities can make decisions quickly whilst others can't. So for example, at Cancer Research UK we have a large team and we have lots of legal and other experience, so we can make lots of decisions in the moment. However, in smaller charities where legacies are quite infrequent, that might not be the case, and sometimes an executive board or even trustee in a smaller charity may need to make decisions, and that might depend on their availability to do so. So it's definitely worth being mindful that it may take some charities longer than others to get back to you, but behind the scenes they're obviously working on it. Similarly with deed signing, could be a deed of variation or something like that. I think the issues are similar to governance and decision making. So some charities will require trustees to sign. Other charities may have implemented specific authorities which allow others who are perhaps more readily available to sign, for example, under a seal. With documents that need multiple signatures from charities, it's therefore worth getting them out early or getting them executed in counterpart, so that the transaction isn't waylaid by any time that it might take to get all of the relevant charity signatures on it. And lastly, on this slide, there's just a little bit about receipts. So as you'll be aware, professionally drafted wills will often require the receipt of the treasurer or other proper officer in order to give a valid discharge to the executor. Who may sign is often set out again in the charity's delegated authority, and as with the last two headings, it may be an easy task or one that takes slightly longer depending on what level of authority needs to sign and their availability. So right, I mentioned capital gains tax a moment ago. Let's have a look at that now. So to discuss it in context, let's have a go at this question. So a house in the estate has increased in value by £15,000, so will attract capital gains tax. The beneficiaries are all charities. How do you deal with the sale? So first option, transfer the property to the charities. Second option, pay the tax that isn't covered by the executor exemption from the estate. Third option, limit the sale to a £12,000 increase, then you're covered by your annual executor exemption of £12,300. Or the last option is something else. So take a moment and when you're ready, continue. So what is the answer to this question? So transfer the property to the charities. but I've also given a half mark, so to speak, if you've put something else. So let's have a little look at that. So fundamentally, it's important that the property is beneficially seen as the charities. This will then enable the benefit of the charities exemption from CGT to be applied to the sale proceeds when the property is sold. One way to achieve this is, of course, to transfer the property to the charities as per the answer on the last slide, and for the sale to then be effected in their names. But there is also a much simpler way of doing things, particularly when multiple charities are concerned, and that is by means of appropriating the property, hence the second answer that I gave on the last slide. So what does that mean in reality? Well, the executor can enter into a memorandum of appropriation, which has the effect of ensuring that charities are regarded as being beneficially entitled to the proceeds of sale, whilst the legal title remains in the executor's name. Effectively, the executor is acting as a bare trustee for the charities. There are certain compliance requirements you should be mindful of in the Charities Act 2011, sections 117 to 121, as well as appropriation. These sections are quite complex, but broadly what is required is the charity must obtain advice from a suitably qualified surveyor before they enter into any arrangement to dispose of their property. This will be by what is commonly referred to as a Section 119 report. The report will detail what the best terms are that the charity can obtain from its disposal of the property. For example, should it be auctioned, sold through normal market testing? Is there scope for planning potential? Should that be exploited? Would that increase the value of the plot? In what financial range should the charity be seeking to secure a sale? So the surveyor would be expected, as required, to give some advice on all of these key things. And it's important, therefore, to note that the report must be gained before the transaction is entered into. Charities will often have a preferred supplier to provide such reports by surveyors who are specialists in this area, and often at the preferential rates that I was mentioning on the last slide. So once this report has been obtained, the charity trustees need to consider it. The trustees should carefully consider their general duty to act prudently, and also have a duty to consider professional advice appropriately, but ultimately it is their unfettered decision whether to proceed with the transaction or not. Certain statements need to appear in the contract and transfer deed if we do go ahead with a sale of the property, and most charities will be happy to provide you with the specific wording required. It's important to note that non-compliance leads to void rather than just voidable transactions, so please do take the time to make sure the Act is complied with. Most legacy officers are well versed on the requirements, so do reach out to discuss it with them. Let's look at the misdescription of charities now. So let's have a go at this question. So a will leaves a £20,000 pecuniary legacy to cancer research. There is no address or charity number. What would you advise the executor? Would it be that the gift fails? Would it be that they should distribute it to Cancer Research UK as the legator worked in their local charity shop? Would it be that they should distribute it to the Marie Curie Cancer Care? The legator had said she was going to leave them a gift. Or would it be to seek a direction from the Attorney General? So the answer is to seek a direction from the Attorney General. So let's look on the next slide at why that is the case. So one of the key things I'd love for you to take away from this presentation is that there is no charity called Cancer Research. I'd be rich if I had £1 for every time that we've been referred to as Cancer Research. So regrettably and all too frequently, a simple check isn't done at the will drafting stage to check that the charity exists, and personal representatives are then left with the problem of disposing of gifts to non-existent charities or for charitable purposes where no particular charity has been selected by the testator. In other words, we end up with a corrupt title situation. So the process to follow is a direction from the Attorney General under the Royal Sign Manual direction, if there are no trusts, and it would be a scheme if there were trusts. So the Royal Sign Manual direction identifies, or it seeks to identify, the charitable beneficiary whose identity was previously uncertain, and the personal representatives must then administer the gift in accordance with the direction from the Attorney General. So when is it not used? Well, it can't be used to construe a will. If by construing the will as a whole a charity can be identified, then the personal representatives can pay the legacy to that charity without the need for a direction. So, for example, a gift to Cancer Research followed by the address of Cancer Research UK is capable of being construed as a gift left to CRUK. It can't be used to resolve a dispute over the validity or construction of a will. The Attorney General will generally not make a direction if he is aware that there is or may be a dispute pending. And also, it doesn't protect the personal representatives from challenge from persons claiming to beneficially be entitled to the gift in question. So it's just worth bearing that in mind. In determining how to dispose of the gift, the Attorney General adopts the same approach as would be adopted by the court. The factors to which he will have regard are what were the testator's intentions as expressed in his or her will. A gift to Cancer Research will be applied to a charity which conducts research into cancer. Extrinsic evidence that suggests the testator had a particular charity in mind when he or she made the will. For example, sometimes there will be a record of a testator donating to a particular charity during his life, or support of a shop, or it might be that they have in fact pledged a legacy to a particular charity. These things are all useful bits of evidence to support what might have been the testator's likely intention. The Attorney General will then consider all the evidence, and a direction will normally be made in accordance with the testator's perceived intentions, although the Attorney General is not bound by these. As I mentioned earlier, if a trust is involved, a scheme is needed, and what this means is you need authority of the Charity Commission and the court. But in respect of direct gifts, the Royal Sign Manual via the Attorney General can be used. Most of the bequests made under this are fairly small, and by far the most common use for the Attorney General's direction here is in respect of gifts to Cancer Research, and a significant proportion of wills that come before the Attorney General are homemade, where they've not received professional advice. There is, as a result of most of the gifts being decided under this being related to cancer research, there is actually a cancer research rota. There are a lot of charities that do serve cancer research, so there's a particular rota system in mind to fairly deal with gifts that can't easily be placed to any one particular charity. In terms of advantages, before we finish on this slide, a direction under the Royal Sign Manual procedure has two really. It's cheap and it's quick, and that's because the Attorney General doesn't charge for a direction. Except in cases where there is a dispute, a direction can usually be made within weeks, so it's very quick and efficient. Okay, so moving on to incomplete gifts now, let's have a look at this question. So the legator writes a cheque for £50,000 4 days before his death and presents to his friend as a gift. It remains uncashed at his death and the residue passes to a charity. So what can be done? And there's 3 options here. Can it be treated as a donatio mortis causa? Can you approach the charity for an ex gratia? Or must the gift fail? So just have a think about what your options are. So you can approach the charity for an ex gratia, and it's not a donatio mortis causa here. So this is one of the cases that we've seen at Cancer Research UK, and to be a donatio mortis causa or DMC, it must have 3 requirements. So it must be made in contemplation of death, contingent on the person dying, and the gift must part from the donor. And case law shows that the uncashed cheque is seen as being an incomplete gift and therefore not a DMC. And this is the case even where a cheque is cashed but not cleared until after death. So we can't proceed further down that route, but that doesn't necessarily mean that the gift will have to fail. The charity can be approached to consider what we would call an ex gratia payment. So just in terms of background, a charity simply doesn't have the same freedoms and discretions as a private individual would to give away part of its entitlement. It may not lawfully expend its funds other than in support of its charitable objectives and in accordance with its governing document without first obtaining the authority of the court, the Attorney General or the Charity Commission. So what are the criteria for an ex gratia which can be sanctioned by the Charity Commission? So the Charity Commission will only authorise an ex gratia payment if the trustees of the charity have no power to make the proposed payment, but in all the circumstances regard themselves as being under a moral obligation to make it. The testator's wishes remain paramount. It is his intentions that must be weighed. A testator has a right to dispose of his property in the way he wishes, not as a family member might prefer. So it's worth keeping that in mind. And in a typical situation, a legacy officer will need to ascertain the following. So what were the true intentions of that testator? Was there a note or a witnessed conversation about a new will or intention to leave a further gift? What had the testator done to try and affect those intentions? For example, it could be that instructions had been given to solicitors to prepare a will. What had prevented the intentions being carried out? And often, taking that last example, instructions could have been given to a solicitor, but then death may have intervened and stopped the will actually becoming finalised. Was there a long or short timescale involved? Generally, the shorter timescale, the more indicative it is that that is the testator's wishes. If it's a longer timescale, again, using that example of will instructions, it could be that the testator has simply changed their mind and therefore not followed through on a new will. And also, does the claimant have a legal remedy? For example, could a claim be made under the Family Provision Act or under proprietary estoppel? Or is it a DMC? And we discounted that here, but that could be on another turn of facts a possibility. If there's a legal remedy, one shouldn't be considering an ex gratia. So a key case on ex gratias is Re Snowden, as on the slide, in which it was said that the power to authorise an ex gratia payment is not to be exercised lightly or on slender grounds. The trustees cannot conclude that they are only under a partial moral obligation. You either are or you are not. And as mentioned already, if the claimant has a good legal claim, but for whatever reason chooses not to pursue it, perhaps because of the costs being disproportionate to the benefit, the ex gratia regime does not apply. If the trustees agree to an ex gratia, it then needs to be authorised by the Charity Commission before the gift can be effected. And please note it can take some charities some time to reach their decision, as this may be dependent on a trustees meeting taking place. If there are several charities, it isn't essential that they all agree. They would all come to their own decisions and make their own applications to the Charity Commission. To progress the consideration of an ex gratia, the trustees will need evidence to show that the will does not dispose of the testator's estate in the manner in which he intended, and evidence to show why the testator was prevented from giving effect to his or her real intention. It is therefore helpful to consider these issues before approaching a charity. The evidence may be statements by independent people as to the testator's true intentions. In due course, the Charity Commission will respond with an order authorising each charity to agree payment or refuse permission. On the last note on this slide, the law does not provide for any difference in approach regardless of the size of the claim. However, where the amount of money involved is relatively small, say £1,000 or less, the trustees may feel that it would not be proportionate to apply for authority to make an ex gratia payment, and it is generally accepted that such de minimis payments are acceptable. So now moving on to contentious, I've just got one case study question for us to work through to sort of demonstrate the sort of approach that charities take, and then just a final slide on the Charity Commission principles that guide charities in how to consider contentious matters. Right, so using a real case that we've seen at Cancer Research UK, let's work through this question so you can get an idea of the sort of way that charities approach contentious matters. And the question is, mother and father make wills before having their daughter. They never get around to updating them. Both sadly die, leaving her aged 15. The estate passes to Cancer Research UK. What happened first? Is it a family provision claim was entered into? Is it a deed of variation was entered into for her benefit, or was it mediation? So have a quick think, pause if you need to. Let's reveal the answer. It may surprise some of you, but what it was that actually happened first was a deed of variation was entered into for her benefit, so the benefit of the bereaved child. So why was that? Well, we took a pragmatic approach as the sole beneficiary of this estate and looked to expedite things as soon as possible so as not to cause further costs and distress for the bereaved minor. The 1975 Act requirements would have been met on the basis of initial communications that we had had with her representation, and we're also mindful of the potential for negative PR if we did not handle this sensitively. We ended up giving up the whole of our estate entitlement, and the solicitors acting for the bereaved minor were appreciative of the approach that we took. We'd most likely have ended up in a similar position if we had progressed matters formally, perhaps with a formal family provision claim having been entered into, perhaps followed up by mediation, but the net effect would have been more costs, more time incurred and less passing to the daughter. So this was a good result all round. The Charity Commission publication CC38 on charities and litigation provides useful guiding principles in how contentious matters should be dealt with. The quote on the side in the bubble is a good place to start, and this is taken from that publication, and it says, trustees have a general duty to act in the best interests of their charity. They have a duty to protect and, where necessary, to recover assets belonging to the charity. So that duty to protect and recover means we have less discretion than that of an individual to accept a claim made against us. So at the very least, we need to understand the merits of the case and the prospects of success. This will often entail quite a lot of requests for detail. We therefore find it's helpful for a solicitor to advise their clients about a charity's duties up front in order to manage their expectations. And it's worth flagging that a lot of charities have highly experienced, legally qualified people acting as legacy officers. A charity will need to be commercially minded about their approach. Supporters who fund charities would not expect a charity to pursue a case if the value of the claim would be disproportionately small. So charities will also take a commercial view to settlement. It can sometimes be more cost effective to make a relatively small offer to settle, taking into account the future and other costs if the charity continued to pursue the matter. and regard will always be had to the means of the opposing party to pay the claim, even if the charity wins. In most estate disputes, this isn't an issue because the estate is available, but in cases where perhaps a misappropriation of funds or similar is an issue, admittedly in only a very, very small amount of cases, perhaps, under misuse of powers, under a power of attorney, there would be no point in the charity expending further charitable funds to pursue a defendant who has already spent the monies and has no other assets. Above all, PR is a guiding force to charities throughout much of what we do. Our reputations account for everything. Without good PR, we would not have our supporters, and without supporters, we would not be able to fundraise or provide for the great work we all do towards our charitable objectives.
Thank you for your time. I hope you found that useful. And if there's anything further you'd like to ask, please do get in touch with us via the email address on this slide. Thank you.
Thank you, Maria. As Dr. Sam said at the start of this presentation, we are extremely appreciative of the probate and will writing work that you are continuing to offer clients at this difficult time, particularly those firms that have maintained access to the Cancer Research UK free will service throughout lockdown. We want to finish with a very quick overview of the free will service and highlight some of the measures we have taken in recent weeks to cope with lockdown before we finish with our contact details and a link to our new Legal Professionals Hub. The Cancer Research UK free will service operates all year round in all jurisdictions of the UK and is open to anyone aged 18 and over. There are no fees to be part of the service and there is no obligation on clients to leave a gift to Cancer Research UK. Invoicing arrangements are simple. Once the will is completed, the firm sends an invoice for the agreed fee to Cancer Research UK for payment attached to the client's pledge form. This allows us to measure the efficacy of the service, which is a requirement of the Charity Commission. The free will service is promoted in many ways, including national TV and newspaper ads, direct mail, events and online promotion. In recent weeks, we have taken additional measures to adapt to the COVID-19 crisis. Our legacy administration and partnership team have moved to work remotely. All the documentation for the free will service can now be found online. We've updated the listings on our website for firms offering free will service to include website addresses. Clients can now check individual firms' access arrangements. Our legacy administration team are accepting BACS payments and working through email and phone to assist with all probate and executory matters. Finally, we have launched an online Legal Professionals Hub where documents, information and contacts can be read and downloaded. So, it only remains to say a final thank you for your support and to provide you with an email address for any queries you may have and the link to the Legal Professionals Hub.